Good afternoon, Ms. Traynor.
Good afternoon, my Lord. My Lord, the next and final witness today is John Wilkes from the Equality and Human Rights Commission.
Good afternoon, Mr. Wilkes. Good afternoon. Right, when you're ready, Ms. Traynor.
Thank you. Mr. Wilkes, I wonder if we can start by your full name, please.
John Wilkes.
And your role in the Equality and Human Rights Commission?
Yes, I was appointed as Head of Scotland in April 2017, and that's the role I still have.
You have provided a statement to the inquiry as part of a Rule 8 response, which forms part of your evidence today. And for the benefit of our records, the reference for that statement is SCI EHRCSX and number 2. That is a very detailed and lengthy statement running to some 68 pages. Within it, you also reference a number of supporting documents, reports and the like, which you've also provided to the inquiry. So your evidence today is intended to supplement that statement and the related documents. There will be many, many things, I'm sure, within that we're not able to cover today. So please be reassured all of that information is, of course, before the inquiry, and I know you're aware of that. I wonder if we can begin perhaps by discussing the organisation, what it is and what is its purpose.
Certainly. The Equality and Human Rights Commission is a regulator set up by Westminster and the UK government in 2007. It has the responsibility of regulating the Equality Act 2010, and it took over the responsibilities of a number of previous equality commissions. And it also has responsibility. So we have responsibility for regulation and promotion of equality, with specific reference to the Equality Act 2010, and also more of the promotion of human rights through the Human Rights Act. We operate across England, Scotland and Wales, and we have a range of regulatory powers, tools and also duties that we have to carry out in the performance of our obligations.
You are an organisation which I think is independent of those governments, is that right?
Yes, we're totally independent of all governments in Scotland, Wales and England.
I think in paragraph 12.9 of your statement, you tell us in January 2020 the organisation had some 201 staff, 16 of those who were Scotland-specific.
Correct.
And dealt with Scottish-related issues.
That's correct. Because of the way that devolution operates, we have to have groups of staff that, in a sense, mirror staff functions in the rest of the Commission. So we have groups of staff dealing with policy and advocacy, research, legal and enforcement, compliance, communications, and all the rest of it. So it's a small team, but it has to cover all those different functions within the specific Scottish context. We also work, obviously, very closely with the rest of the organisation and our GB, England and Wales counterparts.
You mentioned duties, specifically, I think, falling in terms of the Equality Act, and more encouraging compliance with the Human Rights Act. I wondered, how does the organisation go about fulfilling the duties that are imposed on it?
Well, we have a strategic plan that we have to lay before Westminster every 3 years, and that sets out the agreed strategic priorities of the Commission for that period. So it could be, for example, that we would say there's a particular issue in this area like health and social care or employment, and we want to do some specific work. But obviously we also have to take into account that things will happen and things will come up. So we always have built into our strategic priorities the ability to respond to different events, to carry out whatever the most appropriate response might be to that, whether that's some policy influencing or some research or some regulation or some enforcement.
When you talk about regulation, who is being regulated?
Well, it depends. We're responsible for regulating the public sector equality duty. So in Scotland, that would be the 170 or so listed public bodies. So our main focus with public bodies is to give them support and guidance and try and help them improve their dealing with their responsibilities under the public sector equality duty. But we also can take organisations to task where there have been breaches of the equality law. So, for example, we're currently working with organisations like IKEA, as an example, with reference to sexual harassment issues, or McDonald's. So we can also support individuals who have cases of discrimination, either by intervening in employment tribunals or taking standalone cases. And we have intervention in court powers as well.
You, I think, tell us at paragraph 7 of your statement that you engage with the government not by right but by request.
Yes.
What do you mean by that?
Well, we don't have an automatic in with the government. We have a duty under the Equality Act 2006, which sets out our responsibilities, duties and powers. We have a duty to advise governments where they are introducing regulations or legislation that has an impact on equalities. So we can advise them of that. It doesn't mean they have to follow the advice, but we would certainly be very keen in terms of setting out our views. We also engage with legislatures, including the Scottish Parliament here, and respond to many inquiries, consultations along those lines as well.
We, earlier today, commencing this morning, heard evidence from Professor Angela O'Hagan at the
Yes.
Scottish Human Rights Commission, which I think you're aware.
Yes.
Can you help me with the difference between the two organisations?
Certainly. We're the Equality and Human Rights Commission, and we have the powers and duties I've set out. We operate across England, Scotland and Wales. Our human rights responsibilities with respect to Scotland is that we are responsible for human rights for reserve matters to Westminster. The Scottish Human Rights Commission has responsibilities under their powers of promotion and advice with respect to human rights on matters that are devolved to the Scottish Parliament. That's set out in the Equality Act 2006. I think Schedule 1, Section 7, which sort of says Scotland human rights. It doesn't mean that we cannot do human rights work on devolved matters, but it does mean that if we are minded to do that, we would need to seek their formal consent. So because of that, we have a good working relationship. We have a sort of memorandum of understanding about how that relationship operates.
Now, my questions for you today necessarily focus on the organisation's role in relation to equalities and human rights matters, of course, during the pandemic. You start, I think in your statement, you tell us at paragraph 15 that as early as the 9th of April 2020, you, as a commission, published a statement from the chair explaining how you initially intended to respond to the developing situation. I wondered why, at that very early stage, you thought making a public statement like that was something that was important.
Well, I think we thought it was very important in our role as the regulator and promoter of equality and human rights that many aspects of what may yet at that stage come through a pandemic would have equality and human rights implications. We were also aware that the Equality Act would still be enforced, that responsibilities that various bodies and organisations have would still be in effect. And we felt it was really important to say really early on that our role would be to remind organisations, governments, whoever, of their responsibilities, but also to try and work proactively with whatever was coming down the track to advise and sort of hopefully help to make whatever enactments or policies better, and also take into account the needs of the protected characteristics and non-protected characteristics identified in the Equality Act. And we know from previous evidence that we live in an unequal society, and that there are certain groups who have particular characteristics, who are going to be more impacted maybe from decisions that would be made. So we felt it was very important that we set that out right at the beginning, and that we internally made ourselves ready to be able to deal and respond to those developments.
In terms of your internal changes, can I take it from that then that there was work which was ongoing at the time, and that
Yes.
perhaps took a back seat in favour of more pandemic-related tasks?
That's absolutely correct. We looked at the strategic priorities we had at that stage, and then we either deprioritised or stopped work already on certain items that we were doing. I suppose the one that springs to my mind is we had a sort of programme of work around transport, and we just decided we would deprioritise that. We set up an internal COVID-19 standing group, which I was a member of, which met daily to assess what was happening in the outside world, whether we needed to respond, what engagements, what information or requests we were getting. That's how we, in that period of time, or April through September of 2020, was how we responded at that time, as well as, you know, like every other organisation, having to deal with the impacts of the pandemic and staying at home and all those sort of things as well.
The organisation was, I think, involved from a relatively early stage in engaging with the Scottish Government in relation to the emergency legislation that was then later passed, what became the Coronavirus Scotland Act 2020. From an equalities and human rights perspective, when you learned that emergency legislation was being discussed and proposed, what issues were you bringing to the attention of the Scottish Government when it became clear that was going to be necessary?
Yes, we wrote immediately to the responsible minister when we understood there was going to be emergency legislation setting out the importance of ensuring that equalities and the equality obligations were clearly set out in that legislation. That was followed up with a phone call with that minister and various people within our commission to underline the points that we were making. The minister agreed that that was important, and the subsequent draft legislation did set out, I think in Schedule 9 or Para 9, about the approach and having equalities from a public sector equality duties type approach built into the legislation. So in a sense, we're very pleased that the government took that on board quite enthusiastically.
I think you tell us at paragraph 32 of your statement about that telephone meeting,
Yes.
and the date given is the 31st of March, and what you say is the EHRC was particularly interested in potential differential impacts on different communities and protected characteristics and how that could be monitored. Why was that the most important thing at that time?
Because we know from the previous work we've done, we know from the evidence that exists that there are groups in society, some of whom are covered by the Protected Characteristics of the Equality Act, that would have differential impacts of any policies, particularly in an emergency situation. So disabled people, older people, for example, ethnic minorities. So we wanted to ensure that built into any legislation that was being passed to, deal with the COVID pandemic, that those elements were absolutely core and central to the considerations to produce better policy, better services, and that met the needs where they might be different for different groups of people. So that was our driving force as to why we wanted to ensure that was enshrined in the legislation.
You also mentioned in the same paragraph that, as well as that, another matter of importance that you saw at that time was in clear review and end points for the legislation. Again, why was that key?
Because we knew that emergency legislation and the nature of it might mean some compromise with respect to people's rights or equalities, and so having very clear endpoints so that these things didn't become, embedded in ongoing legislation really important. And that review is very important because you don't always know how the impacts are going to work at the beginning of any such process. So the ability to have review points and change or end parts of the legislation were really important in our view.
In paragraph, you go on to list a number of the issues that are raised, and I think it's fair to say they're fairly vast in nature. We'll be able to get to some of them in the context of your evidence today. But one of the specific issues which I wanted to ask you about is raised in paragraph 36 of your statement, where you mention a conversation taking place between yourselves and one of the Cabinet Secretaries, and that conversation being in relation to the reporting of statistics and that information be disaggregated by protected characteristics wherever that is possible. Yep. I wondered why was that important, and do you know if that request was acceded to?
It's important because for the things I've said before about understanding the impacts of whatever it is you're doing, services or legislation, on different groups of people, you need the data to show that. And we know from our work before and through the pandemic and ongoing now that one of the key barriers to effectively doing that is the lack of good data broken down by particular protected characteristics. We understand the difficulties and challenges in doing that, but we felt it was really important to make that point, that in addition to having included in the legislation the advancement of equality, lifted from the PSED type phraseology in the Act, that it was important to where it was possible to ensure we collected or services collected as good quality data as possible. The Minister was very open to that suggestion and said they would try and put that into the guidance as best as they could. We both recognised, though, that there were challenges in gathering good data, which hasn't come about just because of the pandemic, that there are already systemic issues that we're trying to resolve, or organisations are trying to resolve on an ongoing basis. But we felt it was really important to make the point at the start, let's set out and collect data as best we can, as good as we can, so that we can spot where certain groups are maybe have differential impacts in terms of what's being proposed. So that was the reason we were quite keen on that point.
And were there, you mentioned just generally there being a challenge in relation to obtaining good data, particularly during this time. What did you foresee as the potential challenges with collating good and disaggregated data?
Well, if data wasn't collected as well as we could, then there may be issues that are happening to certain groups that would be hard to spot, and then you might spot later down the line. So certain disabilities, for example, certain ethnic minorities. So that's why we felt it was really important to underline the point, as we do with public bodies who have obligations under the public sector equality duty, that to ensure that they fulfil their responsibilities, that having good data is really, really important.
I'll go on to raise the issue of data perhaps later on.
Okay.
I wanted to go back and ask you about the development, as it were, of the Coronavirus Scotland Act. We've already mentioned, of course, that you made representations and some observations in relation to what initially should be included.
Yes.
At paragraph 40.5 of your statement onwards, you tell us your involvement in relation to provisions of that Act that were going to expire. Do you recall the issues surrounding expiry that you drew to the Scottish Government's attention at that time?
I suppose 40.5 talks about the submission we made to the COVID-19 committee of the Parliament. So they had put out a call for views on the provisions, and so we basically, with them, reiterated the points we had said to government in terms of the importance of the things that we had raised with government, and why that some provisions should be kept really tightly controlled. So it was basically that, what we'd said to government, we were saying to the committee in Parliament.
I think you go on to mention some particular provisions which you saw a potential difficulty with.
Yes.
You say you supported the expiry of a provision which, had it been commenced, it would have removed important safeguards in relation to detaining people under the Mental Health Act. You also mentioned concerns in relation to children in secure accommodation and the operation of children's hearings. Can you tell us briefly some of the difficulties with those provisions and why they required, in your view, to be removed?
Well, we've had ongoing concerns and issues in relation to how people who are vulnerable in those situations, who are detained under mental health law, and particularly groups within that, like disabled and older people, need particular protections. So we were very concerned that in the focus of having an emergency, that measures might be put into place that wouldn't recognise or take into account those particular needs, and they might suffer as a result of that. And similarly for children.
Around a similar time, so in September of 2020, not only were you consulting in relation to the 2020 Act and the expiry of certain provisions, but within the organisation, I think you tell us at paragraph 17 that by that stage you, as an organisation, had decided to focus on particular groups and the impact on particular groups. Yes. And you tell us that you were focusing, or your intention was to focus on ethnic minority groups and social care.
Yep.
I wondered, why did those particular groups, now 6 or so months into the pandemic, stick out as those who required particular attention? Yes,
so with respect to ethnic minority groups, we had a body of evidence about the impacts and the inequalities that are faced by those groups. I think by around September 2020, we were aware of emerging reports about the issues facing people from ethnic minorities in health and social care who are working in health and social care. It seemed to be disproportionate to other workers, and we wanted to know a little bit more about why that was. So we decided we would use our inquiry power. We have a section 16, it's called inquiry power, where we can initiate an inquiry into an issue or things like that. And because of the powers we have around that, we can seek evidence. And so we decided we would set up an inquiry to look at the issues facing black and ethnic minority workers and other ethnic minorities in lower paid grades in health and social care settings. And separately to that, on social care, we were concerned about how social care decisions were being made. So we set out to do another inquiry looking at the impact of social care and how decisions were being made. We wanted to do the ethnic minority inquiry was a Britain-wide inquiry. The social care inquiry, we initially wanted to do it as a Britain-wide inquiry, but it was going to cover both equalities and human rights. And in Scotland, because of what I've said previously about our relationship with the Scottish Human Rights Commission, we discussed that with the Scottish Human Rights Commission, who said that they were going to do a body of work about social care in Scotland from a human rights perspective. So they would rather we focused on the equalities perspective. So we ended up doing an inquiry in England and Wales on social care covering both equalities and human rights. And in Scotland, we did a separate programme of work to complement what SHRC were doing and came out with a lot of guidance for social care providers in terms of their obligations and responsibilities under the Equality Act.
I will go on later, I think, to touch on the black and ethnic minority work that that was borne out by the instigation of that in September of 2020.
Yes.
Shortly after that, so in October of 2020, and this is at paragraph 18 of your statement, you tell us about a report titled How Coronavirus Has Affected Equality and Human Rights being published as part, I think, of a wider series of reports that you were already doing. You tell us that that report made targeted recommendations for governments of the three nations that you're covering. Do you recall what those recommendations were in terms of the Scottish context?
So I should say that this report, we have a statutory duty to produce what's called a State of the Nation report about equalities and human rights, which it's up to us to a large degree about what we say, but it's supposed to be how this is progressing or regressing, as the case may be. We're obliged to do it at least once every 5 years, but on average we do it once every 3 years. At that time we called the reports Is Britain Fair, and we produced separate Scotland and Wales reports noting the different contexts, which is called Is Scotland Fair, Is Wales Fair. The previous one we'd published was in 2018, and we'd published a separate Scotland report. We felt it was pertinent and relevant to produce the next report in the middle of this pandemic. So what the report does is it gathers, we don't necessarily produce our own research. What we do is we use government and other national data sets and other sources of research and evidence that are out there at any particular point. We particularly look also for evidence that comes from organisations that can show lived experience of particular groups, and we put that together in a report. And at that time we did it against a measurement framework which comprised of looking at education or health or employment, and we would set out against those measurements an analysis of the data sets as best we could in terms of how they were impacting on the protected characteristics defined under the Equality Act. So this was a report done under that auspices. In that report we did make a range of recommendations to the three governments. I can't remember quite the detail of everything, but we said to the Scottish Government they would have been recommendations under each of those domains of education and health with respect to the pandemic, from what we were seeing from the emerging data. So I think we made recommendations in terms of how employment issues should be dealt with and taking into account the needs of certain groups. In terms of education, I think at that point there were talks about schools being closed and the impact on. I couldn't say for any specificity without looking at the report again. I'm sorry. And we obviously in Scotland what we did with the Scottish recommendations is alerted the relevant minister, the Equalities Minister at the time, with the report and with a set of recommendations. Now, the response of the Scottish Government to these series of reports, where we do make recommendations for them, is actually quite thorough. What they tend to do is look at the recommendations for them and they would write back to us. They certainly did with the 2018 report, and they've subsequently done in the 2023 report, and said, this is the recommendation to us and this is how we propose to meet it, or we're not going to do that. In that regard, we did send the report and the recommendations to the Minister, I think, 20th of October. We didn't get a formal response because of everything else was going on, but we did have a subsequent meeting not a few days after that with officials in the Government Equality Unit, where we covered a number of issues, including the recommendations from that report we just published. And they certainly, in line with their previous approaches, said they would consider it really carefully and take on board where they could.
Turning perhaps into more specific areas which you have engaged with throughout the tenor of the pandemic, the first area broad area in which you touch is the imposition of public health measures and the communication surrounding those, including matters of public confidence.
Yep.
Pertinent to that is your involvement in discussions in relation to vaccine status certification, and you talk about that, I think, at paragraph 44 of your statement. First of all, when we're talking about vaccine status certification, what do we mean by that term?
I think those were the proposals about developing a system where people could confirm their status, whether they're positive or negative, I think, if I recall correctly.
Whether they have or have not been vaccinated.
That's correct, yes.
Vaccinated, sorry.
We raised a number of issues about that process and how it might impact in a discriminatory way, potentially, with certain groups. And I think we raised issues around the facial recognition that was being proposed, which subsequently didn't go ahead, because we know from evidence already that certain facial recognition technology doesn't work well with certain ethnic minority groups. We also raised the issue of data collection, because I think initially the data collection was quite limited, and we said again that we felt data should be quite, as far as you can, extensive through different protected characteristics. And we also, I think, described the risk of scope creep. The way the legislation was drawn was quite narrow and tight, and we were supportive of that, but we did feel that once the system was in place, that perhaps, I think that we used the example of employers might use it in a way that it wasn't designed to be done to ascertain the status of their employees, and we felt that on one level that could be a human rights issue, but also that could disproportionately impact on certain groups. So, for example, in the hospitality industry, where there's predominantly young people work, if employers were using the app in a way it wasn't designed to do, it would have a disproportionate impact. So those were the concerns that we raised.
Particularly in relation to the concerns that you had about employers gaining information about their employees, what kind of scenarios are you talking about in that regard?
Well, as I say, employers using the information to make decisions about their workforces which weren't appropriate was our main concern, and particularly from our perspective, whether that would unfairly impact on maybe people from ethnic minorities or people with disabilities, or because there may be certain instances where certain groups weren't able to take the vaccine, and then they shouldn't be disproportionately disadvantaged by an employer because of that. I think were the sort of things in our minds at the time.
And when you're talking about scope creep, I suppose the employer-employee issue might be an example of it, but scope creep generally, what does that mean?
Well, it could be where the status certification could be used in ways it's not designed to be used, out with the scope that's set down. I mean, and we were keen to ensure that there were clarity by government in terms of what the vaccine status certification was there to do, what it wasn't there to do, and that there were measures put in place, to identify where that wasn't happening. Obviously, we might have had a role in that had matters been brought to our attention where that was being used inappropriately and to the disadvantage of people with particular protected characteristics, and then, some of our responsibilities might have become engaged at that point, but I don't recall that was the case in any of this that I can recall anyway.
My next question was going to be, did any of the concerns that you raised materialise, but I think you've answered that.
They may have done, but they may not have come to our attention, and certainly there's nothing I can recall that we felt we had to do as a result of that. And as I say, certainly some of our concerns, like the facial recognition, I think ultimately decided not to use that anyway, so I think they did consider quite carefully, I think, would be my response to the concerns we and many other people and organisations were raising at the time.
moving away from the issue of vaccine status, I wanted to touch on the issue of health and social care, because I know you have set out earlier that certainly social care was an aspect which you saw fit to focus on as a particular area of importance.
Yes.
You highlight issues with policies and guidance to do with both elderly and disabled people in terms of receiving critical care at paragraph, I think, 48, beginning at paragraph 48 of your statement. I wondered if you could summarise perhaps the issues that you think arose at that time in relation to critical care for those groups.
Yes, we were concerned that the guidance was really clear for people who needed to operate it, frontline staff, that they understood their requirements and obligations under the Equality Act, and that decision-making wouldn't happen where people with particular needs were disproportionately or adversely affected. Again, people with disabilities, maybe older people. And those were our concerns, and we also obviously reminded government that in the production of the advice guidance that it should be under their obligations of the public sector equality duties be subject to quality impact assessment. And there also in Scotland is the socio-economic duty, which we are broadly the regulator of as well, which covers a similar approach but looks at socio-economic perspectives as well. So we were clear with the government to remind them that in the development of important things like this, that they should be taking into account those aspects, because if you use equality impact assessments properly, then it can throw up issues that say, oh, right, okay, the way we're designing this service is actually going to have a disproportionate impact or may not be appropriate for this particular group. So if we amend it this way, then we have a better chance of ensuring that, it serves everybody properly.
I think it's at paragraph 50, you talk specifically about a concern in relation to the application of something which is termed a capacity to benefit quickly test. Can you summarise perhaps that particular concern?
Yes, this is the British Medical Association who set out this policy, and we were concerned that it was too widely drawn, and that we felt that there were risks that in making decisions, people shouldn't be taking into account non-relevant health conditions or impairments that should play a part in decision-making about the efficacy of the treatment that they wanted to apply. So disabled people, for example, have a range of conditions, and we felt there was a risk that when this guidance came out, the healthcare staff might misinterpret and bring into play other conditions that shouldn't be brought into play. And similarly, that also applies to older people who often have other conditions as well. So we felt it was too widely drawn and was open to misinterpretation. And we wrote to the BMA and we did get a response. And they said they would update their guidance to take into account the points we were making.
Another issue, I think, in which you highlight, I suppose, some measure of success, however that can be measured, in relation to your representations, is in relation to the application of DNA CPR notices. Can you tell me more about that?
Yes, is that in paragraph?
It's in the next paragraph, paragraph 51.
51. Sorry, let me just have a quick. Yeah, we had a similar, in a sense, a range of concerns about do not resuscitate and the guidance that was being applied. We felt that without a much clearer interpretation and focus, that some of the issues I've mentioned in the previous answer, might be taken into account inappropriately, and that could particularly impact on people in residential care homes, which tend to be older people or maybe disabled people who are in residential care settings. And yes, so we were credited by the Minister for changing those notices, and the Chief Medical Officer subsequently wrote to GP practices about that. So we were pleased with that outcome.
You go on at paragraph 53 to specifically mention the area of physical restraint in residential care. And I wondered, again, if you could perhaps summarise the concerns that you had at that time surrounding physical restraint policies,
Yes.
and whether your views and representations had any success in terms of changing the position.
Yes, so this is not a new issue for us. We've been concerned for a number of years prior to the pandemic and post the pandemic about the lack of consistent statutory guidance about restraint of various individuals in different settings. And we share that concern with the Scottish Human Rights Commission and the Children's Commissioner in Scotland. And at the time that the Chief Medical Officer was putting out the proposals on guidance about use of physical restraint, we felt again that we needed to make quite urgently some key points to the Chief Medical Officer, reminding them that, you know, there are certain situations where actually it's never lawful to use restraint, and we didn't feel that the initial guidelines were clear on that, and that there's a legal framework and safeguards that wasn't being put aside that still needed to be taken into account. And we were concerned that the guidance didn't clearly set that out well enough in certain situations and patients that the guidance would apply to. And we were particularly concerned on the implication for people like children where restraint is sometimes used in certain settings. So it's an area of concern to us, which is why the three commissioners wrote to the Chief Medical Officer. And to be fair, I think they did amend their initial guidance as a result of that. But as I say, this is not a new issue for us and goes on to this day, really.
In paragraph 55, you narrate in July of 2020 your then chair of the Commission giving oral evidence to the House of Lords Public Services Committee, raising, I think, a range of concerns, but in particular to do with older people who live in residential care, and that them as a group being a particular focus. Are you aware of specifically what concerns were raised by the chair at that time?
Yes, this is so July 2020 was still relatively new into the pandemic, and I think already at that stage, like many others, we were aware of emerging evidence that would suggest that there was disproportionate deaths of disabled people, older people, for example, which are people with protected characteristics that we have an obligation around, and particularly in care homes. And that was emerging evidence, and we felt in the opportunity to the House of Lords Public Service Committee to make those points, and also raise issues about the barriers that might come into play around some of these issues. And it was also a factor that led to our inquiry decision a bit later on that year to look at sort of issues of social care decision making. So I think our chair was quite keen to ensure that we were making those points really early on in the pandemic, when it wasn't maybe huge amounts of concrete evidence, but there was certainly emerging trends that were coming into the public domain that we felt was important as the Equality and Human Rights Commission to raise.
I think one of the perhaps themes or trends of concern in relation to care homes that we have heard a lot of evidence about is the restrictions on visiting. Mm-hmm. I wondered if the organisation had a view as to whether residents were protected in relation to the issue of visiting.
I suppose that sort of ties in more to people's rights under the Human Rights Act. So because of the delineation of responsibilities that we have in Scotland between ourselves and the Scottish Human Rights Commission, I think we were conscious that the Scottish Human Rights Commission were making a lot of those points. As I say, we were more focused at that point on providing the guidance for social care providers on their responsibilities under the Equality Act. I think we were aware of it. I don't think we made particular comment about it because of the fact the SHRC were looking at that as well.
Moving swiftly on, because of course we are constrained by time, but there are just such a multitude of issues which you cover within your statement. But I think the next one, which I wanted to focus on, is the issue of workers and employment generally, and particularly in relation to paragraph 92 of your statement. You mention, I think, that you produced new guidance for employers, again quite early on in the pandemic. You say May 2020, in relation to equality issues. And I think you liaised with the Scottish Government in relation to that guidance that you were producing. And you say in paragraph 92 that you asked them to cascade that new guidance. Who was it being cascaded to, perhaps obvious, and what was their response to your request?
Yeah, so the reason we wanted to bring out the guidance, I mean, it's about existing responsibilities that employers have anyway, but we were concerned that in the context of the pandemic, where everybody was being furloughed, that there were particular potential risks that would happen to people who had protections under the Equality Act. For example, pregnant women, those on maternity leave, disabled workers who were entitled to reasonable adjustments under the Equality Act, which is an obligation on all employers to consider. And in the context of an emergency like the pandemic, we were worried that employers might not be taking those factors into consideration, which were still legal obligations upon them. So we felt it was important to do that. And we asked the government in Scotland whether it would help by cascading that advice through its networks, which are probably more extensive than ours. And we did engage with employers' bodies that we had relationships with, and they said that they would do that through the networks they had. I think the Business Pledge and the Fair Work, Safer Workplaces schemes that they had, which reached out to quite a lot of employers. So they were very pleased to do that.
In paragraph 96, you discuss your suggestions to the Scottish Government in relation to fair work principles, which I think is something that we've heard about before in this particular phase of the inquiry. But you list a number of issues that you suggested the Scottish Government include to the changes in the policy. Again, do you know whether those issues were indeed taken into account by the Scottish Government?
Yes, I mean, some elements were taken into account in terms of the guidance that they produced and the strategies that they developed, yeah. I can't say it was everything that we said, but certainly the thrust of it, I think they took it on board and said that they would try and incorporate that as best they could.
Turning to paragraph 99, you discuss a call for views that you responded to in July of 2020 regarding economic recovery.
Yep.
And within the context of that, I think you draw comparisons between the pandemic as a crisis situation and the 2008 recession.
Yes.
What does that comparison intend to highlight? Why is that of pertinence?
Yes, so this was a response to a call for views from the Economy, Energy and Fair Work Committee of the Parliament on looking ahead to economic recovery. And we recommend, as you say, a range of issues that the committee should be considering in terms of addressing inequalities. I suppose we saw it as there were a range of inequalities in the economy anyway, and I'm sure you've heard lots of evidence to that effect already. In a sense, the pandemic exacerbated quite a number of those, but it also was an opportunity to, as we were starting to think, or the country was starting to think about how you work your way out of the pandemic when that came, about starting to address those issues. And I think it was a question that the committee itself had asked about whether anybody had any references to 2008, where, of course, there'd been the big economic recession. And we had actually done, in the early days of the EHRC, before my time, I would stress, a piece of research looking at the impacts of the 2008 recession that had happened. I think it was we commissioned the University of Warwick to do a piece of research that sort of looked at the impacts of that recession, and it pulled out the impacts in terms of how women particularly have been affected, how disabled people have been affected disproportionately to others, ethnic minorities, and age, I think. So we made reference to that fairly old piece of research now as a way of saying that's what happened then. There's no reason to suspect that these sort of things won't also reoccur. So it's a good... And we made a number of recommendations, I think, in that research about how you might start addressing that. So that's why we made reference to that as a sort of previous maybe not emergency, but a big thing that hit the UK, which was an economic recession at that point. And that's why we felt it might have been helpful to look back at that. I don't think we included that research in our submissions to you, but I have subsequently found it. And if you might find it useful, we can certainly send that on.
On the next page, but in relation to the same paragraph and the same call for views, essentially, there are a number of groups who you refer to and highlight, in particular those, for example, working in the gig economy,
yep.
self-employed people, those without recourse to public funds,
yep.
and those who need adequate and available childcare. Particularly with reference to these groups, why were they important, and did the Scottish Government take any action as a result of your proposals or your concerns?
Yeah, I think we set out a number of issues of potential concerns and risks that we think might have happened, because we also, like others, I think, were recognising that the economy itself was changing through the pandemic, greater working at home and all of those aspects, and that looking at how that might impact on the economy coming out of the pandemic, we felt it was important to flag where we understood from the evidence we had that some of the elements of those aspects of the economy disproportionately impacted on certain. So in the gig economy, for example, you tend to find that higher proportion of ethnic minorities, and at that time there were much less employment rights. I think case law has subsequently demonstrated that people in the gig economy do have some employment rights. So, but at that time that was an issue. The issue of childcare, it was a perennial. So I think we were trying to sort of point to issues around the challenges that the economy was facing and what opportunities as well coming out, and how we might use that to address some of the issues that were already present, inequalities in the economy. So one other example might be that before COVID, maybe there was much less home working. Post-COVID, much more homework. And that could be to the advantage of people, for example, with disabilities, who might find it much more challenging to be in an office-based scenario, but could be much more effectively supported if the employer applies the reasonable adjustments duties to working at home. So there was a sort of range of issues that we thought was important to point to and make recommendations about. And I think your question was, did the government take that on board? I think in terms of the COVID recovery strategy that it published in October 21, I think one of the three pillars of that was addressing systemic inequalities made worse by COVID. So in a sense, they had reflected that. I'm sure it wasn't just us who were making those points, but I think we sort of saw a reflection of those concerns, certainly at a very high level in the strategy. Obviously, there's the issue of implementation and the details of everything else that goes along with that, but we did feel there was a sort of recognition of those elements.
You've already referenced, I think, a piece of work which the organisation, I think, decided fairly early on in the pandemic in 2020 to inquire into, and that's the impact of COVID on ethnic minorities.
Yep.
And a report was published on that matter.
It was
2 years later, in June of 2022. It's paragraph 131 of your statement in which you tell us that that work was being undertaken.
Yep.
I wondered if, and given the time constraints on a fairly high level,
I'll try and be brief.
are you able to summarise perhaps some of the key findings of that piece of work?
Yes. So again, as we said in 2020, we were concerned of the emerging data that suggested that people who are in the lower paid grades in the health service and in social care providers, who predominantly tended to be also ethnic minorities from ethnic minorities, seem to have a disproportionate experience compared to other groups. So we set up our inquiry in 2020 to look more deeply into the causes of that. I mean, we went in obviously having a suspicion of something, and often with our inquiries, and what we want to do is try and see whether that is proven to be the case. So we looked at how people were employed in both the health service and social care sector. We looked at policies, procedures. We looked at pay. We looked at the sort of tasks that were allocated, the ability of workers to seek redress, training, development opportunities. I think what we found is that there were different experiences being seen within England, Wales and Scotland because of the the way that healthcare and social care had evolved in all those three nations. I would say that from a Scottish perspective, the situation was better than, and in Wales better than you might have seen in England. That was one of the sort of outcomes, and we produced separate reports from that address the Scottish situation, the Welsh situation, and the English situation. So broadly, though, we found that there was, not a great surprise to us, incomplete data about the whole workforce situation. Better in the health service because it's more structured, but particularly in adult social care because the provision of social care is done through many, many more providers, so it's much more difficult to get good quality data about what's happening in social care. There was clearly different treatment and experiences at work from people in ethnic minority communities. And during the course of the inquiry, we did speak to, either through trade unions or through the opportunity we set up for workers to speak to us directly about their experiences across England, Scotland and Wales. And we spoke to employers, of course, as well. We found that commissioning and outsourcing, particularly of social care, tended to lead to poor pay and insecure work. We found that within those groups, ethnic minority workers, that there was a generally low awareness of their employment rights, but also a fear of raising concerns and a lack of mechanisms, particularly in social care, to do so. So we set out on the back of those findings a range of recommendations in Scotland to the government, various regulators such as the Care Inspectorate and Scottish Social Services Council, to NHS providers and others. And the thing about an inquiry under our Section 16 powers is that where we do produce reports and make targeted recommendations, that the recipients of those recommendations need to pay due regard to our recommendations. So they have to, in a sense, address the recommendation with us. It doesn't mean they have to follow it, but they do have to consider it. So at the end of, I think we published the report in June 2022, and we had a round table with the various bodies I've described who we were targeting recommendations at. I think it's fair to say that most of the recipients of our recommendations were very keen to work with us and to think through about how they could adopt those recommendations. There were more for government overall than others, and we've met with them subsequently on a sort of roughly annual basis since then. I think we've recently just had a final set of meetings. Clearly some of the issues are not easy to address, some are more easy to address, so some of the more systemic issues are going to take a long, long time. But some of the findings and recommendations from our inquiry have been adopted and are being delivered and through various frameworks and legislation and so forth that government and others are doing.
You mentioned there, I think, data again.
Data.
And throughout the various topics that you raise within your statement, it seems to be an emerging theme that the data is perhaps not as complete as you would wish it to be. Reflecting back on the collection of data and what that tells us and what that's able to tell you as a commission in relation to equalities and human rights, what are your reflections about that and how we should treat it?
Well, good quality data which tries to capture as best as you can what's happening with different groups is not a new issue for us. As I said before, it was an issue before the pandemic. It remains an issue today. And we recognise that organisations, there are challenges to collecting good quality data. It can be about size of populations. If you're an employer with a particularly small workforce, for example, that can be quite difficult without compromising people's, confidentiality and those sorts of things. But certainly we continue to advise and work with public bodies who have responsibilities under the public sector equality duty that, to deliver your obligations, you need good quality data and you need to keep working on gathering that. And it's also true of other types of organisations, private sector and otherwise. If you are trying to ensure that your workforce, for example, that you're dealing fairly and equitably with all elements, you need to understand your workforce. And obviously from our perspective, there are the Protected Characteristics in the Equality Act that are good guides to some of the issues you might face. And you're obliged, they have obligations as employers to do that. I think since or during the pandemic, I think the government set up a quality data improvement project, which seeks to improve the quality and how and gathering of good quality data, both within government and across the wider public sector. And we're certainly part of that group, and it's been ongoing for a few years now. So there have been efforts put in place to try and continue that improvement of gathering data. But yes, if you don't know what's happening, if you don't know who's affected, then it's really hard to put into place appropriate services or good policies. And that's one of the issues I think we continually are up against.
Turning towards the end of your statement, I think at paragraph 145, you reflect on your involvement, and you say much advice was given by EHRC to the Scottish Government.
Yep.
And it's difficult perhaps to tease out what element of success that your representations had, and what effect, if any, they had on public policy. But what you can confidently say is that some decisions were subject to amendment following your advice.
I think some I've said already about the emergency legislation, about the Chief Medical Officer's guidelines. I think there are clear areas where we can point to, yes, they have changed that as a result of our involvement, and that's very welcome. But we recognise that many other organisations and interests were also making similar points. And the important thing is not who makes the point, but the important thing is that the issue is dealt with. I think our role as a regulator gives us a particular, I think, if that's the right word, probably isn't the right word, with government, because we are a regulator and we can regulate them as well. I think they're very conscious of that. So I think they do take note of what we say. They are very responsive, for example, as I said before, to our recommendations. And I think talking with colleagues across the HRC, I think there's a general sense that both the Scottish and Welsh governments were very open, I think, to what we had to say as an equality regulator, and very open to the issues of how do you make sure that everything you're doing is meeting the needs of the entire population. I think it was maybe with the scope of this inquiry, but the UK government may be less easy to deal with.
More generally, towards the end of your statement, you share, I think, some reflections about society in general, and the importance of human rights and equality coming to the fore during the pandemic. And I wondered if perhaps that might be a nice way to end and to leave us with some reflections about what generally you think society learnt as a result of the pandemic.
Yes, if I may, I'll very quickly say that some of the lessons I think we learned ourselves were equality and human rights needed to be at the heart of public policy making and service delivery. The importance that the pandemic threw on the obligations of the Equality Act and why that is there and why it's important. The importance of public bodies continue to undertake their obligations under the public sector equality duty. That much of the advice was quite well received. Where we had good relationships, that was easier to do. Where we had less good relationships, like the British Medical Association, it took longer. We also saw the movement of lots of services in a very short space of time online, and there were risks as well as opportunities around that. And some of those we're living with to this day. We made the point that we felt that government particularly didn't necessarily utilise the expertise that many of the organisations that you've had evidence from over the last 2 weeks, the expertise they have in terms of some of the specifics around you looking at disability or trans people or whoever it is. And that, if they had a better engagement with them, they would have been had access to lots of useful information. That we learnt for ourselves the need to be flexible and proportionate. So we tried to help by easing some of the reporting requirements for public authorities during that period. I think we paused the collection of gender pay gap data. I know other people who've given evidence have different views about whether that was the right or the wrong thing to do. We've mentioned equality data. I think what the pandemic did throw up was the spotlight on the fact that we are not necessarily where we want to be in as a society in terms of equality and human rights. And when you're dealing with a thing like the pandemic, and you look at some of the statistics about those people who are disproportionately affected, those, the deaths of people and which groups they came from, I think that really threw that into sharp focus. I think the other thing that we viewed, I think, or considered was that the pandemic also at points exposed some of the underlying prejudices that might exist in society, and that the way that played out in terms of looking at who deserves what in terms of service provision, and perhaps the sense that, maybe older people or disabled people were viewed differently during that period than perhaps they should have been. And I suppose for us, it reinforces the point that we need to continue to have these debates about the importance of equality and human rights in terms of creation of fair societies, because where you do have an equal society, then we'll be much more resilient, I think, when we face these crises again.
Thank you very much. Those are all the questions that I have for you.
Thank you, Ms. Traynor, and thank you, Mr. Wilkes.
Thank you.
Grateful for your evidence. Very good. We're going to break for 15 minutes, and then we're coming back for closing statements. So 1:45. Thank you. Now all that remains for the impact stage of the hearings is to hear the final statements. Mr. Gale.
Yes, my Lord. I have only two brief comments to make at this stage. One is of form and procedure, and the other is a more general comment. Beginning first with the matters of procedure, and this is a point of repetition. I made at the beginning of these inquiries on the 10th of June a reminder to parties relating to closing statements by core participants with leave to appear in these hearings that we've just now completed. This applies also to the hearings that took place in the course of this year, considering the impacts on the justice system and worship and life events. Your Lordship issued a direction in respect of closing statements on the 2nd of May of this year, and directing core participants, if they wish to make closing statements, are due to submit those by noon on the 18th of July of this year. The appendix to that direction contains an indication of those matters that the inquiry would find most helpful to hear about. The more general observation I would make, my Lord, is this is obviously a milestone in this inquiry's proceedings. It is pertinent perhaps to reflect that 5 years ago this country was in lockdown. There was a restriction on the normalities of society which had not been experienced in this country in modern times, even during 2 world wars. And it was done all with the intention of combating the spread of a deadly virus which had claimed already the lives of many, and which would go on to claim many thousands more. 5 years ago, the first administration of an effective vaccine was still 6 months away. Against that background, and in fulfilling its terms of reference, this inquiry has quietly and with determination and purpose gone about obtaining material on which to base a record of the impacts of the pandemic and its restrictions, and to inform our further investigations. This record could not have been obtained without the cooperation of many thousands of ordinary people, as well as established organizations who have connected with the inquiry, whether in responding to Let's Be Heard, in providing statements and other materials to the inquiry, and in giving oral evidence. The inquiry appreciates that for many this would have brought back memories of events that they would have preferred never to have lived through, and which will remain always with them. The inquiry is very grateful to them all. Throughout all its work, the inquiry has endeavored to adhere to its human rights-based approach and trauma-informed approach. In this regard, the inquiry is grateful to those members of the public and representatives of organizations who have expressed their appreciation for that approach. In particular, the inquiry team has been aware of many expressions of appreciation of the way in which your Lordship has conducted these hearings. The inquiry team also wishes to express its appreciation of the way in which your Lordship has directed the inquiry's work. With those comments, my Lord, I hand over to your Lordship.
Very grateful. Thank you very much indeed. Now, today's session concludes our hearings on the public impacts of the pandemic. I'd like to take the opportunity to thank all those who have given evidence to this inquiry about how they, their families, friends, colleagues and communities have been and continue to be affected by the COVID-19 pandemic. Since our first public impact hearing on 24th of October 2023, we've heard oral evidence from 364 witnesses and received written statements from more than 600 people in total. Witnesses had to revisit challenging episodes in their lives when sharing their pandemic experiences with us, and many of the accounts we have heard have been deeply emotional, particularly for those who lost loved ones during the pandemic and those who were denied access to their loved ones in care and nursing homes. The decision to start the inquiry's hearings by examining the impacts of the pandemic was deliberate. As part of our commitment to demonstrating a human rights-based approach, which forms part of our terms of reference, we wanted to allow those who were affected by the strategic response to the COVID-19 pandemic to be heard, and in so doing, have our investigations informed by their experiences. Thanks to you, we have gathered a huge amount of valuable information to assist us in identifying lines of investigation and questions for the decision makers and those responsible for implementing their decisions. While we can only hear from a small proportion of witnesses during our public hearings, all submissions and written statements to the inquiry, including the experiences shared with us by more than 12,500 people across Scotland through our listening project, Let's Be Heard, are being analysed and will help inform our investigations and reports. They will also help share our recommendations to Scottish ministers, which we hope will ensure Scotland is better equipped to respond in the event of any future pandemic. I would also like to share with you today our plans for the remainder of 2025 and beyond, and to provide some information about how the inquiry intends to conduct its investigations and report its findings. We are continuing our investigations with targeted requests for information and documentation, and are taking statements from witnesses for the implementation and decision-making phases of our work. The in-house researchers in our Let's Be Heard team are analysing the experiences shared with us and will highlight common themes and any disproportionate impacts of the pandemic, passing this information to the inquiry's investigative teams. These themes will also be published in a series of Let's Be Heard reports, which will be published next year. Let's Be Heard published in 2023 a preliminary synopsis of responses on the inquiry's website, as well as a case study on the experience of prisoners. Later this summer, it will publish a case study looking at the experiences of children and young people. Unlike the COVID-19 inquiry, which began by investigating decision-making and publishing a report with recommendations for each of its investigatory modules, the Scottish COVID-19 inquiry is structured differently. The Scottish COVID-19 inquiry began by investigating the impacts of the pandemic on the public. We will finish by investigating the implementation of policies in Scotland and the decision-making that underpinned them. This phase will include hearing oral evidence from Scottish ministers and senior officials. We will publish one single final report containing all our recommendations and lessons to be learned. Later this year, we will also publish a series of narrative records which will capture the themes we have heard at the impact hearings and written documentation that is yet to be published. These narrative records will summarise the impact evidence gathered to date by the inquiry. The narrative records will not make findings of fact or make recommendations, as that would not be appropriate until we have heard evidence on implementation and decision-making. Rather, they will serve as a record of what the inquiry has been told about impacts by both witnesses and various bodies and groups. I would like to assure you that in reaching my findings and making recommendations, I will consider all the contributions made to the inquiry's work via the Let's Be Heard project and the impact hearings. This inquiry has already started investigating implementation and decision-making. In the first half of 2026, we will begin to hear from implementers and decision-makers. At these hearings, we expect politicians who were decision makers during the pandemic to provide oral evidence. We will also hear from those responsible for implementing these decisions, including senior civil servants and chief executives of bodies such as local authorities and NHS boards. Our aim is not to duplicate evidence already heard by the UK COVID-19 inquiry. We will receive into evidence relevant evidence produced to the UK inquiry. Where such evidence is being considered by the inquiry for the purposes of hearings, it will be issued to core participants as part of the inquiry bundle. Those authors of documents or statements will not be called by this inquiry to repeat evidence they have already provided. Such witnesses will only be called where the inquiry seeks additional evidence from them in respect of the same or other matters. This will avoid repetition at our oral hearings and incurring unnecessary cost. We will, however, call some of the same witnesses to answer different questions based on our terms of reference and investigations, so that we can examine in greater detail the formulation and implementation of policy in Scotland during the pandemic. In September of this year, Dr. Ashley Croft, who in July 2023 delivered a presentation on the epidemiology of COVID-19, will be returning to answer questions submitted by participants about his presentation. In September, we will also hold hearings focused on lockdown and other non-pharmaceutical interventions and international comparators. Those are not hearings about actions taken by the Scottish Government, as those will be dealt with in our decision-making hearings. Rather, they are perspectives on what actions could be taken by governments to deal with a public health emergency and the factors that need to be weighed when making these decisions. We will hear from experts a variety of perspectives on pandemic restrictions, including scientific, ethical, economic and human rights considerations. These roundtable sessions will also allow us to hear the experiences and views of national and international experts in exploring what lessons may be learned from the range of alternative responses to the pandemic in a variety of countries. These discussions will provide context for the inquiry's implementation and decision-making hearings, at which the inquiry will examine how the Scottish Government came to the decision to impose restrictions on people's movement through lockdowns and other non-pharmaceutical interventions. I intend to finish all public hearings in 2026, enabling us to move into our final phase of report writing. While it is too early to say when I will publish my final report, I can reassure you that the inquiry team and I are working hard to complete our investigation in a timely manner. This involves balancing my desire to publish my report and recommendations as quickly as possible with undertaking a thorough, independent investigation into the Scottish response to a global pandemic that affected us all and continues to affect the lives of many. For the avoidance of doubt, this inquiry cannot investigate policy areas beyond the devolved responsibilities of the Scottish Government. I cannot make findings beyond the inquiry terms of reference, nor can I make any findings of civil or criminal liability or award compensation. What I will continue to do, however, is conduct a robust, independent investigation to establish the facts of how the pandemic was handled in Scotland in accordance with our terms of reference, and make recommendations to Scottish ministers which aim to minimise the impact of any future pandemic. I'll make a further statement about the plans for 2026 in the autumn. And that brings to an end this phase of the inquiry's deliberations. Thank you all very much for your attendance here today and for the past fortnight, indeed for the past 2 years. We'll now adjourn.